Welcome to today's Law Path webinar. My name is Ryan Tan, and today we're going to be covering employment for your business, contractors versus employees. Now, this is a very common topic that is discussed amongst businesses. I'm sure that that's what's brought a lot of you to the webinar today. Again, whether you have a large business or you're simply starting out and you're wanting to get some clarification on whether you should go for an employee or a contractor. What are the benefits? What are the costs? What are the obligations between the different types of labor for your business? So I'll just wait for everyone to pop into the webinar now. While we're getting started, I'm just going to pop up a poll. Now, just let us know with these 5 questions, like what's your company's biggest focus in 2022? What industry you're in? All these kind of things, because it will allow us to customize the webinar as we go through, as well as the Q&A at the end, which we'll have as well. So take a minute to fill that out. And once you're done, also pop in the chat. Let us know where you're coming from in Australia and what industry you're in as well. Awesome. So if you have any questions from today's presentation, feel free to pop them in the Q&A box. There is a Q&A box specifically for questions, and we will get to those throughout the presentation, but also towards the end when Sam holds the Q&A. There's a chat as well, which you can post in. Sometimes if there's a lot of comments, it might get lost in the chat as well. So just keep that in mind. Awesome. We've got Fiona from Melbourne running a music school. Hi, Fiona. Fantastic. So just to cover today's agenda and what we'll be covering through this webinar, we'll be going through a bit about LawPath, who we are and how we can help. A bit about Sam, I'll introduce him to you, and also then we'll get started with the presentation on choosing an employment type that suits your business and fundamentally going through contractors versus employees. And towards the end, we'll do a brief product demonstration of the LawPath platform and how we can help before concluding with Q&As as well. So thank you to everyone who's posting in the chat. We've got Lydia, she's from Sydney in the property industry. So again, thank you for everyone as well who has filled out this poll. We've got people from a wide range of industries here. Fair few people who are customers with us and also who are not customers with us. And a lot of the businesses are more than 2 years old. So this is a great topic because whether you're a new business or you're looking to just revamp your documentation and compliance and ensure that as you're scaling and growing, you're compliant. It's a fantastic topic to revisit, no matter what size or what stage of the business you're in, especially with the recent changes on employment, from award rates to just different changes from a previous webinar we did on legal changes, so superannuation and all the different obligations that you need to follow, especially if you're a company director and the like. So just a bit about LawPath and who we are and what we do. We provide smart, simple legal for small businesses. And we do this through creating legal documents, managing compliance, and connecting you with lawyers on our platform. And this is on demand. So you can speak to our lawyers and also our accountants when it suits you and when you want to speak with them. As you can see, we've served over 300,000 businesses. We've saved these businesses over $100 million in legal fees, and we have over 10,000 verified 5-star reviews on Trustpilot, amongst other platforms online. So we're just getting started on this mission and this journey of serving small businesses with their legal and accounting needs. So how can LawPath help? Well, we offer a range of services. Firstly, we offer contract management for your business. So we do have over 360 documents now on our platform that are all customizable for your business. So specifically on today's topic of employment and HR, we have over 108 different HR and employment documents, everything from your employment contracts and agreements, all the way to, say, conversion letters if you're converting a part-time employee to a full-time employee, an employee handbook, and all the policies for that. So all of those documents are there through the contract management platform, and you can also personalize these with your company's branding as well, and use e-signature to send out and sign and store these documents. So that's the contract management side. We do have a range of personalized workflows as well. So these workflows allow you to, it's kind of a bridge between having a lawyer and having the documents. So we have 8 or 9 right now. 2 of them are specifically on employment, around hiring an employee and firing an employee, specific to, I guess, the specific circumstances of your employee or even your contractor, which we've just built out as well. So they're fantastic to go through. And then lastly, booking in legal consultations. So we have a range of lawyers on our plans. You'll meet Sam in just a moment. He works closely with our legal advice plan clients. And if any time you have questions on compliance or employment law, or you simply want to get some contracts reviewed from our platform or off the platform, you can book in using our calendar link on the platform and be speaking to one of our lawyers, usually in a matter of days. So you can ensure that you're staying fully compliant. So now I'm going to introduce you to Sam. Sam is one of our main lawyers here on the legal advice plan for our customers. He has over 8 years of experience in an array of different legal areas, all kinds of law, and he's a 5-star rated lawyer as well. So I'm going to pass you to Sam, who will take you through the rest of the presentation. Thanks, Sam.
Thanks for that, Ryan. Hello, everybody, and thank you for joining us in the webinar. So my name is Sam. I'm one of the lawyers at LawPath Legal, and my primary role here is to assist our clients with their business legal needs, including employment and business structuring, commercial terms of trade, and intellectual property protection. Employment law is an area that we get lots and lots of queries about. It's I think probably constitutes around about maybe up to a quarter, perhaps even more, of inquiries that we get through the legal advice plan. And so it's a critical area for anybody who's running a business, and also happens to be one of my pet areas of law as well. So I'll just move on to the next slide. Now, we're going to go through a number of different types of employment agreements, employment arrangements, and we will also discuss the differences between an employment relationship and a contractor relationship, as well as the pros and cons and risks associated with each of those relationships as well. Now, before we dive head on into the substantive topic, I'll just give a very broad overview of the different types of work arrangements that your business can enter into with people. And so broadly, you can say that you hire workers as employees, or you can hire them as independent contractors or subcontractors. And if you're hiring them as employees, you can hire them as permanent employees or as casuals. Now, the difference between the two is that a permanent employee has an expectation of ongoing regular work, whereas a casual employee doesn't have those expectations. They have no right to expect that they will be provided with regular work from the business. With contractors, it's a business-to-business relationship. You're basically engaging someone, or perhaps a company, to provide your business with services, which is then perhaps provided to your customers. And so it's a business-to-business relationship. It's not what the law classes as a master and servant relationship, which is what an employment relationship is. And so if you're engaging somebody as an employee, you have a great deal of control over the work that they do. Whereas if you're engaging somebody as a contractor, that person will do work in accordance with their own expert judgment and skill. And you're basically outlining in broad terms what you want them to do, and they'll just go and do it in the way that they see fit. So there are some fundamental differences there, and we'll go into those in more detail shortly. So what is an employment agreement? Well, the basic description is set out in the slide. A lot of the times we get inquiries from businesses that have problems and disputes with employees or workers, and they have no written agreement between that worker and the business. And from a legal perspective, that's very problematic because we don't know what the terms of the agreement are between the business and the worker. whether they are engaged as an employee, whether they're engaged as a contractor, and in either way, what governs that relationship, how much they're supposed to be paid, what their responsibilities are, what the liabilities of the parties are, et cetera, et cetera. And it's very helpful to have a written agreement, written employment agreement, or a written contractor agreement, whatever it is, whatever applies. And if you don't have an agreement, then we strongly recommend that you access our platform. If you haven't signed up already, do sign up and use our templates to generate the appropriate agreement between you and your workers. And if you need any help with that, contact us, and our lawyers and our legal team can help you out with that process. Now, some of the key areas that you need to address in your employment agreement are outlined in the slide. Some of the ones that I find, based on experience, is often missing are things like protections for confidentiality, intellectual property, whether you want to protect your customers from being poached by the employee after they leave employment, as well as conflicts of interest. You know, if your employee wants to go out and set up a business that's potentially in competition with yours, or works for a competitor, then that can leave your business vulnerable. There are, of course, other basic areas that the employment agreement needs to cover, such as pay rates, whether an award governs the operation of the agreement, termination conditions, and so on. All right, so different types of employment agreements you can choose from. Now, I discussed in very broad terms difference between permanent employees and casuals, and permanent employees you divide it up into two types: permanent full-time, permanent part-time, and we'll go through differences between those shortly. All right, so before we go ahead, we've got a couple of poll questions. Feel free to just type in your answers in the chat. We're not going to be measuring the answers. Yeah. But the first question is, you don't need to pay, well, true or false? You don't need to pay contractor any super, that means superannuation. So do you think you don't need to pay superannuation to your contractors? True or false? I'll go into a bit more detail about this in a later slide, because there are some misconceptions around what a business's obligations are towards their contractors in terms of superannuation, workers' compensation, etc. And the second true or false question that we'd like to put to you is whether you can terminate a full-time employee with only 2 weeks' notice. And we'll answer those. We'll answer that question in a later slide as well. Just feel free to pop your answer in the chat. All right, full-time employees. So a full-time employee, as I mentioned before, has an expectation of ongoing employment and work. And on average, they will work 38 hours per week. Now, when I say average, that's because in some awards, so awards are instruments that are set by the government, or I should say the Fair Work Commission, to be more appropriate, to be more accurate. And it sets out minimum terms and conditions that apply towards to employees in certain industries, in certain roles. So as an example, the retail industry award might apply to employees who work in retail businesses. The security industry award applies to security guards and so on who work for security companies. And in some awards, it says that the 38 hours per week, that requirement can be averaged out over a roster cycle. So you could have a roster cycle that repeats every 2 weeks or 3 weeks or 4 weeks. And as long as the employee works an average of 38 hours a week over that cycle, they will be classed as full-time employees. You can also require the employee to work additional hours, reasonable additional hours. And if you do, then you may need to pay them overtime, depending on what the award says. Now, with full-time and part-time employees, you need to give them notice before you can terminate their employment. Remember that permanent employees have a right to expect regular ongoing work. And so if you're going to terminate their employment, you need to give them notice. Now, the poll question we had before, it said only 2 weeks notice. The answer to that is that it depends. And it depends on how long they've been working for you. And it depends on the terms of any award or the employment agreement. Now, the minimum requirement under the Fair Work Act is that if an employee has been working for you for less than 1 year, then you need to give them 1 week notice of termination. If you terminate them on the 2nd or 3rd year of their employment, then it's 2 weeks. Sorry, I think I might have gotten a bit mixed up. If you terminate them, 2 weeks, and then the increment after that is 3 weeks. And then if they've been working with you for 5 years or more, then it's 4 weeks. If they're over the age of 45 and they've been with you for more than 2 years, then you add an extra week on top. And that's just to compensate for the fact that older workers are disadvantaged when seeking new employment as well. All right, so advantages of full-time employees. We've listed them in the slide. I mean, the employees, they feel they have ongoing work. There's stability in the work that they do. So it goes to follow that the employee might be more motivated to stay with your business in the long term. They're a bit more invested in what they would do as part of their work. From your perspective, your immediate financial outlay will be less than, say, hiring a casual employee who's entitled to a casual loading of 25% on the base rate. And you don't have to, there's probably less administrative overhead dealing with, changes in roster cycles, changes to start and end times, and prorating the accrual of leave and so on. There's also a mention in the slide for an employee share option plan. Now, this is not necessarily restricted to full-time employees, but there is a method to incentivize employees to stay with your business in the long term by devising what's called an employee share option plan or an employee share scheme, which gives the employee options or a right to purchase shares in your business if your business is operated by a company. And there are some tax incentives that attach to that if the scheme or the option plan meets certain legal criteria. Just reach out to us if you have any questions about the employee share option plan or share scheme. That's a whole separate topic in itself. Part-time employees. So basically a part-time employee is someone who works less than 38 hours a week. With part-time employees, you fix a regular set of hours that they are required to work over a roster cycle. Basically, if the worker works outside of those agreed hours, then it would usually be treated as being overtime. And you can reasonably require the employee to work additional hours. The worker may refuse, and you would have to then balance out the personal circumstances of that worker versus the business operational needs, and try and negotiate some sort of compromise. Part-time employees are also entitled to notice when being terminated, and the notice doesn't change from full-time employees. So full-time and part-time employees both have same entitlements to notice before being terminated. Part-time employees, the advantages in engaging a part-time employee might be cost savings. Your business might not have enough work to engage somebody on a full-time basis, and so it'd be more appropriate to engage someone on a part-time basis to align with the workload. It also opens up the pool, the talent pool that you can tap into, because there are a lot of very experienced, skilled, and well-qualified workers who can't actually work full-time. They might have care commitments, they might be studying, they might have some other personal circumstances that don't allow them to work full-time, but they can still be positive contributors to your business. And so hiring those workers, if you're looking to hire somebody on a part-time basis, if you're open to that, then it allows you to access a greater pool of talent. It's also handy if you have created a role that doesn't have full-time, that doesn't require a full-time work, that doesn't require somebody to work a full-time workload, but it's something that you're considering and seeing whether it's a role that you should expand into the future. And so you can experiment. And so we're engaging a part-time worker for that role. You can experiment to see whether that role is something that's good for your business and you should expand it or not. The slide here mentions seasonal. This is not necessarily restricted to part-time workers. It can also apply to full-time as well. You can engage permanent employees on a fixed term basis or what's called maximum term basis. There's a slight difference between the two. But yeah, basically it's a temporary contract that you engage somebody on a temporary basis. And that's just for you to be able to fulfill seasonal needs. You might not need a worker at certain times of the year, but you might need a worker in some other times of the year. So there are industries like accounting, financial services, as well as agriculture, that is highly seasonal. And so fixed term or maximum term employment can be beneficial if you're trying to meet workforce needs in those times. Bit of a segue to that, casual employees. So if you engage somebody on a casual basis, it provides you with probably the maximum amount of flexibility. So you can vary their work hours and dates to meet your business operational requirements, subject to the worker agreeing to work those days and hours. There is no guarantee of ongoing regular work for casual employees. And so it follows from that casual employees are not entitled to receive notice of termination unless it is stated in their employment contract. Now, I have come across instances of casual employees being terminated whilst they're working. Usually leaves a bad taste in people's mouths when that happens. And quite often in employment agreements, it's normal to include some nominal period of notice, like it might just be 1 day, just so that you're not booting somebody out whilst they're still doing work in your business. Casual employees don't receive paid days off, so they don't have entitlement to paid annual leave. Instead, they get a leave loading of 25% on top of their base rate of pay. The way that the leave loading works, it depends on the award. Some awards will set pay rates for casual employees, including penalty rates and overtime rates, and it'll give you a sum, an overall sum with all of those factors included. Some other awards, it'll set out pay rates and then tell you to add 25% on top, and there can be some slight difference in maths. But basically, the idea is instead of getting paid days off, they get a casual loading of 25% on top of their base pay. Casual employees can work full-time. They can also work part-time on a regular basis as well. Important thing to note is that if your casual employee works regular hours and they work those regular hours for at least 6 months, and they've been with you for at least 12 months. So they've been with you for at least 12 months, and the last 6 months of their employment, they've been working regular hours. You may be required to convert them to permanent, full-time or part-time, depending on the number of those regular hours. I'll go into that in a little bit more detail, but it's an important point to consider. Biggest advantage with casual employees, flexibility. You can adjust, when you give them shifts, you can adjust the amount of work depending on the amount of workload that you've got available for them. Very handy for seasonal work, especially in areas like retail, hospitality. Casual employment is extremely common, along with healthcare as well, particularly in the social service, aged care, disability support sectors. Casual employment is very, very common in those fields. Unfair dismissal. Because casual employees don't have an entitlement to regular ongoing work, they do not access right to claim unfair dismissal if they are dismissed. That said, if you dismiss them on an unlawful basis, such as based on discrimination, or they've made a query to you about how much they're being paid because they think it's wrong, and then you boot them out because they've had the temerity to challenge you on that. If they're exercising some workplace right, or they've got some protected attribute, and you dismiss them, because of those protected attributes, or because they've exercised the workplace right, they can still bring a claim, proceedings against you for general protection. So you can dismiss them, but you cannot dismiss them unlawfully. No legal entitlements, so you don't have to worry about calculating those. No redundancy pay, usually no notice of termination unless you allow for it in your employment contract. Casual employments are also used to assess whether a worker is suitable for your business. And so you might gradually increase the number of hours they work until they become a full-time worker or a regular part-time worker. Now, there is a mention here for about casual conversion, the risks. So, as I mentioned before, if somebody has been working for you as your casual employee for at least 12 months, and the last 6 months, they've been working hours that are regular, they've been working regular hours, then you may be required to convert them to permanent full-time or part-time. Now, if you're a business with less than 15 employees, so in other words, you are a small business under the Fair Work Act, you're not required to proactively offer them conversion. However, the employee is entitled to ask for conversion, and you must seriously consider it and balance out that request against your business's operational requirements. So let's say that somebody has been working a regular set of hours in the last 6 months, they've been with you for 12 months, they've come to you asking for conversion, but you foresee that you actually can't give them regular hours. You can't keep doing that, and perhaps in the next couple of months, you're going to have to reduce those hours or make those hours irregular. And so if you can genuinely see that that's going to be a problem, then you're not required to convert them, but you need to explain to them and respond and say, look, this is the reason why we're not converting you. You're also required to let the employee know, even if the employee hasn't made a request for conversion, you're also required to let the employee know that you're not going to be converting them if you're not going to actually do that, and outline the reasons why. If you have 15 employees or more, so you're not a small business for the purpose of the Fair Work Act, then you are required to proactively offer them conversion within 21 days of their 12-month anniversary. And if you're not going to be offering them conversion, you need to let them know and let them know why you're not offering them conversion. And as I said, your business operational requirements will be the reason why you can't offer them conversion, because you foresee that they're not going to have you're not going to have a workload that warrants giving that person regular hours in the foreseeable future. Okay, so now we move on to contractors. I'll just address the difference between employees and contractors. So employee, they are working for your company. They represent your company. They need to be loyal to your company. They need to keep your company's confidence. Now, sorry, when I say company, I mean your business. Might be operated by a company, it could be a sole trader or a partnership, doesn't really matter. But the general principle is that as an employee, there is a duty of confidence, there's duty of loyalty to the business that they're employed by. Contractors don't actually have any of those duties. A contractor is a business operator in his or her or its own right. and you are basically hiring another business to provide services to you. Whether that service is provided to you or whether you're on providing that service to your client. With contractors, there's no minimum rate of pay that are set out under employment law. It is a business-to-business transaction, and so how much fees you pay them depend on the amount that's negotiated. Contractors, because they are operating a business in their own right, they have a greater degree of control over how they do their work. Basic idea is you give them a set of deliverables that they have to meet, and they need to deliver on those. But they can exercise their own judgment and skill in meeting those deliverables. They can accept and refuse jobs at their discretion. They don't get sick or paid leave. There is no requirement, unless you say that there's no requirement for you to give them ongoing or minimum amount of work, unless you bind yourself to that under the contractor agreement. Now, and also they will send you tax invoices for their fees, which you'll then have to pay, like in any business-to-business relationship. If you hire a contractor, pretty flexible arrangement. You negotiate the workload, you negotiate the fees. So everything is really up for negotiation. Now, having said that, you need to be very careful that the terms of your agreement don't indicate that the contractor is in fact an employee and not a contractor. All right. And the reason for that is because if the terms of a contractor agreement, right, you might label an agreement a contractor agreement, but if the terms reflect an employment relationship and not an independent contractor relationship, the courts or the Fair Work Commission can decide that the contractor is in fact an employee. And that decision will carry consequences, such as being liable for leave, being liable for long service leave, liable for unfair dismissal, and a whole bunch of other things, superannuation, workers' compensation, et cetera, et cetera, et cetera. Now, there is no sharp, clear line that divides contractors from employees. Instead, the courts and the Fair Work Commission will weigh up different factors. And so it'll look at things like the level of control that you have over the contractor. It'll look at whether the contractor is required to represent your business. So, do you require them to wear a uniform? Do you require them to wear a name badge? Do you require them to use your business's email address instead of their own business email address, and so on? Whether you have whether you take on any liability for their work, or whether they are wholly liable for what they do. As well as provision of equipment. So do you provide them with equipment, or does the contractor provide their own equipment? And if it's the latter, then they're more likely to be treated as a contractor. If you're the one providing them with equipment and gear, then you're more likely to be, they're more likely to be deemed to be an employee. So there's a whole range of different factors. Now, the case of on-call interpreters that's mentioned in this slide here, it is a little bit dated, but still very instructive. Now, that case involved a company which had engaged roughly about 2,500 language interpreters and translators as independent contractors. The company, when this case was decided back in 2011, the company had been trading for quite a long time. And back in 1989, it sought an opinion from the Australian Tax Office about whether those contractors would actually be deemed to be contractors, and if the company would need to pay them superannuation. And the ATO wrote back to them and said, no, you don't have to pay super, they are contractors. Later on, though, the ATO changed its mind and pursued the company for breaches under the superannuation legislation. And the ATO's assertion was that these people were to be treated as employees for superannuation purposes, and the company should pay super. Case went all the way to the federal court, and the ATO won. And some of the key issues here were, first of all, whether these so-called independent contractors were employees under general law, under common law, judge-made law, And secondly, if they weren't employees under general law, whether they fall under the expanded definition of employee under superannuation legislation, because under superannuation legislation, the definition of employee is not your usual definition of employee under general law. It's far expanded. The court decided that they are, in fact, employees under general law. And some of the key issues there was that the translators and interpreters were required to wear the company's uniform, wear the company's name badge, and basically represent themselves as being part of the company, as acting for the company. The other issue was that most of these contractors didn't actually have any established business of their own. And in fact, they got all of their work from the company itself.
Sorry, I'll just take that call off. Sorry about that. We're back.
Sorry about the technical interruption. Yeah, so where was I? Yeah, so these contractors didn't have established businesses of their own, and the overwhelming majority of their work came from the company. And so there was a bunch of factors that weighed in favor of them being employees rather than independent contractors. But the judge made an interesting comment that even if that were not the case, they would still be entitled to be paid super because they fell under the expanded definition of employee under superannuation legislation. Now we posed a poll question earlier asking whether you think you don't have to pay super to contractors. Now, if you've engaged a contractor, you do have to pay super. If you have engaged them for their personal service and labor, and you pay them for that personal service and labor, and they have no right to delegate their work to their own employees or their own subcontractors. Now, what that basically means is that you need to have engaged the contractor personally, so not via a company. So if you've engaged a company as a contractor, then that doesn't apply. But if you engaged a sole trader as a contractor, and you are requiring them to provide their own personal skill, so they're not able to delegate that work out to their own employees or subcontractors, they have to do that work themselves. And you're paying them on the basis of their labor, such as based on an hourly rate or a piece rate, or a payment per engagement with a customer or client, for example, then you are liable to pay superannuation. If you have engaged them and you pay them to achieve a particular outcome, such as gyprocking a house, or achieving a milestone in the project, as opposed to an hourly rate or a daily rate or a piece rate, then again, they don't fall under the expanded definition of employee for superannuation, so you don't have to pay super. If you've engaged them to provide personal service and you're paying them for their labor, but under your contractor agreement, you give them the right to be able to delegate the work to somebody else, then again, you don't have to pay super because they have the right to, they have the power of delegation under the agreement. On that last point, there is a bit of uncertainty around whether it's sufficient for the contractor to have a theoretical right, but not practically be able to do it. So an example of that might be, say, if you've engaged a psychologist or a counselor as a contractor. It would be quite unusual for a psychologist or a contractor to delegate a consultation with a patient to somebody else. That would be very unusual. And so in that sort of case, there's an open question as to whether that is really an effective power of delegation or not, and whether superannuation would be payable in that circumstance. So there's a bit of a grey area there, but basically you're liable to pay super if you've engaged somebody personally to provide their personal service. You're paying them for their labour, based on an hourly rate, day rate, piece rate, whatever, and they don't have power of delegation. So just keep that in mind. If you do have to pay super, have a chat to your accountant about how you need to arrange that. Just on that note as well, in a lot of contractor agreements, it's a good idea to have a clause that says if the companies, if your business is required to pay superannuation, then that super is taken to be included in the fees payable to the contractor. Or in the alternative, you can deduct the superannuation from those fees before paying the fees to the contractor. Okay. Now we have template subcontractor and independent contractor agreements on the LawPath platform. I generally recommend that if once you've worked on that document, you get a lawyer to review the document and give you advice on whether it's been done properly or not. Okay, we've gone through some of the risks with contractors. We'll go through a few other ones as well. So with contractors, you can also be liable for their injury suffered whilst performing work for you. The rule around that is quite similar to superannuation in that if you've engaged a contractor to provide personal service, it's not for a trivial amount. I think the threshold in New South Wales is $10. And they're not delegating their work to somebody else, then they can make a claim under your superannuation compensation insurance. That's even the case in some states. That's even the case if you've engaged them as a company, right? And the person who's actually doing the work is a director of the company, and that's specifically so that you're not to prevent businesses from working around the workers' compensation obligation. So just be aware of that. Now, as I mentioned before, if you're engaging somebody as a contractor, they are a business of their own. Your ability to supervise their work is reduced as a result of that, and so you're lacking control over what they do. So the quality of the work that they do might not necessarily be the same as the quality of work from your employees. Right? With your employees, you can closely monitor and supervise how they do their work. With contractors, it's less so. There are also security risks, so protection of confidential information and IP and so on. With employees, there's a common law obligation for employees to keep the confidential information of their employer confidential. There is also a common law rule that if an employee is required to generate intellectual property, so they're required to create intellectual property as part of their role, then the assumption is that the employee assigns or transfers ownership of that intellectual property to their employer. If you've engaged a contractor to create IP for you, then there is no such assumption when it comes to contractors. The generated IP could belong to the contractor. And so your contractor agreement should include protections for your confidential info and assignment of any IP that they create to your company or to yourself or your partnership as operator of your business. Probably the most tricky risk is misclassification. So whether the terms of your contractor agreement reflect an employment relationship rather than an independent contractor relationship. And so, as I mentioned before, if a court or the Fair Work Commission decide that they've been misclassified and they should really be treated as employees, then you've got a whole bunch of liabilities that go with that, leave, unfair dismissal, and all the rest of it. On that note, I'll just also mention the law around deciding whether whether a worker is a contractor or an employee has changed in recent times. There's been a couple of cases decided by the High Court very recently that's changed how we think about that. Previously, the law was that the overall relationship between the worker and the business that's hired them will be considered, of which the written agreement or any verbal agreement is just one of the factors. Now the law has changed, so the starting point is the agreement, and the court or the Fair Work Commission will consider the provisions in that agreement and try and find out whether the provisions reflect an employment relationship or a independent contractor relationship. The courts won't look outside of the agreement unless there is an allegation of a breach of that agreement or some misleading or deceptive conduct, okay, which requires the court to then look at the overall circumstance. But the starting point will be the agreement. And so more than ever, it's vital that any contractor or employment relationship is codified in writing, as you've got written agreement with your employees and contractors outlined, specifying the precise terms and conditions of their engagement. Right, protecting your business's IP when your employee leaves. All right. So as I mentioned before, your employment agreements should have IP clauses. There's clauses protecting your IP, clauses protecting your confidential info. When you terminate an employee, it's a good idea to send them a letter of termination, confirming that they are being terminated. But also to include a friendly reminder in there about their confidentiality obligations and their IP obligations, right? So if you require them to sign any deed or sign any document, transferring IP over to your company or your business, you should get that signed. If the employee might have possession of confidential documents related to your business, then they should be returned. If they've got electronic copies, they need to be permanently deleted, et cetera, et cetera. So you should outline those obligations in your letter of termination as well. Yeah, so in our LawPath platform, we've got a nice little workflow for hiring and firing employees, and so make use of that when hiring employees as well as when dismissing employees, and reach out to us for advice if you need any help with that. All right, so I'll now pass you back to Ryan.
Thank you so much, Sam. That was a great presentation and a very good overview of contractors versus employees. Just briefly wanted to go into a recent survey of that we did amongst our customers last year, and we find that around 80% of individuals and 87% of small to medium businesses can find it difficult to access the legal services that they need. They feel that it takes a long time, it can be expensive, complicated, and there's a perception that they're not ready for this kind of support. But like Sam has said, everything that he's mentioned, all these kind of documents are on the platform, and we've got lawyers who can give advice on this as well. So just recapping how LawPath can help. We have our contract management facilities on the website, which has over 100 different HR and employment related documentation, conversion letters, employment agreements, confidentiality agreements, and non-disclosure. Just wanted to really highlight the fact that these employment agreements, they're very high quality in the sense that some people say, I want to get a free document from Fair Work or from the local council, and a lot of the time that those documents do not include provisions around non-compete, restraint of trade, and intellectual property protection clauses. So again, keep in mind, firstly, if you are getting free templates from somewhere, that firstly, they're based on Australian law, not US. And secondly, that they do have all these specific clauses. And that's where the documents library comes in handy, and it asks you questions, and based on your answers, it will then pre-populate and fill out that agreement so that it's compliant for your specific business, because you don't want to use a template that doesn't know who your business is. Creating personalized workflows around hiring and firing employees, all the legal and non-legal steps in there, and they will walk you through it, including directly linking you to the documents. So it's a matter of clicks before you creating your first document and ticking off everything. We do have a bunch of resources in there, so ebooks, there's a bunch of other things in there, templates for job interviews and things like that that you can kind of copy and paste to make life easy. And then booking in legal consultations. So speaking with lawyers such as Sam, Damon, we've got plenty of other lawyers on the legal advice plan who are on standby to help your business. So just in terms of our plans, again, about half of the people on this call today, you're already members with us, likely on the legal advice plan. So you do have these benefits available to you and to book in a call. But just to recap, we've got our essentials plan on the left, which is the documents access, 350 plus documents right there. Our legal advice plan is the documents plus the consultations. So you get the unlimited 30-minute consults on new legal topics with our lawyers. So employment and all the intricacies within employment are covered within that. There's 4 pages of contract review on this plan as well. So if you do need to get any documents reviewed, especially with changes in legislation recently, you can put that through to the platform. It might be a termination letter, it might be other legal documentation that, again, just because you fill it on the platform, it is compliant, but it is always good to kind of book it in and get that reviewed by a lawyer, even if you want to add in a little bit of information. And lastly, on the legal and accounting advice plan, this is a phenomenal plan in which we've partnered up with our friends at Pop Business. They're one of Australia's most highly sought after chartered accounting firms. The team, Pat, and all those people over there, they're working with our clients doing accounting consultations. So you do get unlimited 30-minute calls with our accountants. Again, if you have any accounting matters, such as like group structuring, asset protection, going through all kinds of, taxation minimization strategies and preparing your year-end return. Again, this is a great plan, and the lawyers and the accountants do speak to each other on this plan. So specifically around your business, if you're looking at your business structure or even things around employment, the accountants will be aware of what's going on so they can give you a more tailored experience. So just for everyone here, as a recap, this is the legal workflows here. As you can see on the left-hand side, we're continually building these out. We just added one in for hiring a contractor, which we didn't have previously. So hiring an employee, a contractor, and dismissing an employee, they're all there. But there's a range of other legal workflows there as well, such as collecting a debt, registering a trademark. If you're setting up a website or a blog and you need some website documents, but you're not sure, besides your privacy policy, what other documents you might need, they're all listed there, as well as a family trust and a non-disclosure agreement as well. This is a brief sample of what the workflow looks like. So it will be broken down into several parts. So for example, it's not necessarily legal things, but it will go into how you can arrange a reference check for the employee, contacting contractors, and then obviously, completing the decision tool for the working arrangement for super and tax purposes, like Sam said, whether you need to pay super or not. So we've got an offer today for everyone on this call. What you can do is you can get access to our legal advice plan, 20% off the full rate with monthly payments. So typically we've done this on an annual price point, and you'll see this on the website. You'll see that it's $1,440 annually or $120 per month. But again, today we're offering 20% off this, and we're also doing it on a monthly price point. So if you've listened to this presentation, you've heard what Sam said, and you think that you could get some real benefits from the lawyers looking over your contracts, advising you on compliance, you can refresh your documentation and policies. That's available to you. We do have a 3-month trial as well to our legal advice and accounting plan. So again, like you saw on the previous slide, this plan is normally $293 a month. Even for that, it's phenomenal value considering it has chartered accounting support in there, but we've got a 3-month trial around 30% off. So it's just $199 a month for 3 months. That's it, no long-term commitments or contracts. It could be a great plan just to get on board and refresh your compliance. So if you do like either of these plans, either the legal advice plan or our legal advice and accounting trial plan, comment yes in the chat, and one of our team will give you a call this afternoon to walk you through this. Now, perhaps you might be a LawPath customer on the Essentials plan or an older plan, and you're interested in upgrading your account and you want to use the credits on your account. In that case, you can still type yes in the chat below, and one of our team will reach out and give you a specific call towards your account and how we can help you. So I'm just going to pass it over to Sam. We're going to keep the question and answers for 5 to 10 minutes. So yeah, keep these questions quite brief, but I can see that we have a bunch of different questions here as well. So I'll pass it back to Sam for the Q&A.
Thanks for that, Ryan. I might just come back to the notice of termination. I had a bit of a brain freeze during the presentation there. So if you're dismissing somebody, if you're terminating a permanent employee during the first year of employment, it's 1 week notice. Second and third year is 2 weeks. Fourth and fifth year is 3 weeks. And if they've been with you for more than 5 years, it's 4 weeks. And don't forget the extra week they get if they're over 45 and have been with you for at least 2 years. So I'll just go through the Q&A. Do casual workers get super? Yes, they do. It's a fairly simple one. Okay, somebody's asked, does this mean, sorry, Bona, sorry, I apologize if I got your name right wrong there. Does this mean that as an employer, we are not liable to pay superannuation? If you're an employer, you have to pay super. There's no getting around that. That is a requirement. Okay, so Umesh, you asked me a question about the payroll tax. Yes, I am aware of that case. So what Umesh is talking about is there's a recent case involving a medical doctor, I think it was a GP, who was paid a percentage of his fees for consulting patients and so on. And the Commissioner of Revenue in New South Wales decided that he was an employee for the purposes of payroll tax, and the medical practice was required to pay payroll tax. Now, yes, so if you, sorry, I've just got a bit of a problem with the screen.
We'll fix it here. There we go.
Okay, sorry about that. So yes, if your business has reached the threshold, the wage bill threshold for paying payroll tax, then you do need to pay payroll tax for contractors, even though they are contractors. So if you're paying them for their personal service and their personal labor, then the money that you're paying them as their contractor fees may be included as part of the wage bill that's calculated for payroll tax. So just watch out for that. Payroll tax rules, they differ from state to state, state and territory. Ask your accountant if you've got any doubts. Okay, Bauna, you've also asked whether we've got a template for contractor agreements. Yes, we do. They're just available on the document library of the LawPath platform. Okay, so Tanya, you've asked me for some examples of differences between hiring a contractor for personal services and to achieve a specific result. So if you've hired someone to, let's say, clean some premises and you're paying them on an hourly rate, that would be hiring somebody for personal services and paying them for their labor. If you've hired, say, a gyprocker to gyprock a house and you're paying them a fixed quoted price for that work, then you're not actually paying them for their labor, but you're paying them to achieve a specific result. Say if I was to go back to the cleaning example, if the contractor was to provide you with a quote for cleaning, say, an office, and you pay them the quoted fee and not based on some hourly rate or day rate, then again, that would be to achieve a specific result. And so they're fairly extreme examples, but I hope that you get the right idea. Sonia, you've asked whether a contractor needs to have insurance, and do you need to ask for a certificate of currency or certificate of cover? If you're engaging a contractor, you should, we recommend that you make them liable for all of their work, and they should have professional indemnity or some other relevant insurance, some other insurance that's relevant to what they're doing. And you should ask for a copy of the certificate of insurance currency, just as a matter of precaution. Augustino, you've asked about contractors located overseas. So a contractor who's located overseas will be governed by whatever labour laws apply in that particular jurisdiction. So you need to seek separate advice about that. There may be some intersection with local, with Australian employment law for the purpose of deciding whether they are employees under Australian law or independent contractors. If your business is based in Australia and there is an Australian link in the work that person is doing. But look, if they are truly a contractor and not an employee under Australian law, then the terms of your contract will govern what laws will apply. But as I mentioned, the local employment laws in their jurisdiction might interfere with that. So I would suggest you seek local legal advice as well. Okay, one more. What about working from home employees and work cover in Victoria? Have a chat with your work cover authority in Victoria about that. But in general terms, if a worker is working from home, then the home is considered to be a place of work, and any injuries that arise when they're performing work at their house would fall under a workers' compensation legislation. Okay. I'll pass back. Thank you.
Thank you so much, Sam, and some great questions. So we had a bunch of other ones we couldn't get to as well today, but I just wanted to thank everyone for attending the webinar. I'm just going to pop up a feedback poll as well. If you could just take 1 or 2 moments to fill this out, this really helps us make the webinars more customized for your industry and ensures that we can bring the best value. If we've missed anything or you'd like something else to be there, then again, please fill that one out. I will put the special offer back on here as well. So again, if you are interested in any of these deals, again, they will be running for today and tomorrow only. So please pop yes in the chat box and one of our team will call you as well. Thank you for everyone filling out this feedback poll, especially question number 4 around what topics would you like to see more of. Employment is a very hot topic. As you can see, over the last month, we've had 2 different employment webinars, especially with all the changes going on as well right now. So it's good to see that people are enjoying these webinars. So I will leave this up now. And just lastly as well, if you would like a copy of the slides that we've presented from today, please comment in the box as well. They're not automatically going to be sent out. We really want to prioritize engagement on this platform as well. If you'd like a recording, please key that in the box as well. It will not be automatically sent out. So I'm going to leave it here, but thank you so much for attending today's webinar. I'll leave it open for the next few minutes so you can pop in your feedback and if you're interested in this offer. Otherwise, we hope you have a great rest of your day and thank you again for attending.